Senior Moments, sponsored by the Empowering Seniors Group on News Talk KVNU, 102 FM and 610 AM.
Good morning. This is the Senior Moments Show. I am your host, Sid Roederer, and we've got an interesting show coming today. Bryce is out of town, and we are going to get to our guest here in 1 second. Let me just talk about our sponsor, which is the Empowering Seniors Group, a group of professionals that have dedicated their time and effort to provide information to seniors, their family members, on all the wonderful people that listen to us every Saturday. If you'd like to learn more about the Empowering Seniors Group, you can do so online at empoweringseniors.info, or you can email us at empoweringseniors.cv@gmail.com. And lastly, if you have any questions or suggestions for this show, you can reach me personally at 435-512-6406. Well, let's get to our guest today. Our guest is Justin Wall. We've had him on before. He is a member of the Empowering Seniors Group. Welcome.
Thank you. It's a pleasure to be here.
It's good to have you here. Justin owns Wall Estate Solutions. He's an attorney at law. And today we get to talk about wills.
Yeah, trying to keep it basic today.
That's good. So yeah, let's dive right into it, because wills aren't as simple. I think everybody thinks they know what a will is, but there's some rules to that.
Yeah, I think it's safe to say most people do know, at least in general, what a will is, what a will does, what it's expected to do. I mean, you hear about wills in the media, in the movies, and other places, and it tends to be somewhat of a dramatic time in people's legal lives when they're inheriting under a will or when they're drafting a will, at least the way that it's portrayed in the media. And I think for that reason, a lot of people know what it's for and what it does. And generally speaking, they know if they want one and if they need to set one up. But they don't know the different ways that a will could be drafted and what makes it valid or invalid and what are the legal requirements for setting up a will. And I think that starts, with the general rule for a will is it is valid if it has two witnesses, right? You need two witnesses in the state of Utah in order to have a valid will. Now, there are some exceptions to that, and there's some add-ons, I guess you could say, where if we have a will that is written in the testator's handwriting, then it doesn't have to be witnessed at all. And so people come out and they, one of the first questions I ever got when I first started out as an estate attorney, I told my cousin I was doing this. And he's like, well, what do we need an estate attorney for? Can't I just write my will on a napkin? And isn't that legally valid? And this is the first time I'd been asked that question. It's like, well, yeah, I mean, it is valid, right? There's a difference between what's legally valid as opposed to what puts you in your best legal position. And that's the world of difference that we're looking at when we're looking at, should we do a will? Should we do a trust? Should we do something else? So generally speaking, when you're setting up a will, you should know, yes, how do we make a will valid? But also, what can we do to make sure that we're putting you in the best position that you can be in for your estate plan? And that's kind of where an attorney really does a good job.
So I'm a little curious because I feel like I can hear stories in the background. So have you had some experiences
Many times
with wills that did not grip because of one or the other thing?
Yeah, so I've had a few of them. People will claim all sorts of things as a will, whatever they can. I mean, usually it's the kids after their parents have passed away, and they'll say things like, you know what, mom and dad really wanted me to have the shotgun or me to have the four-wheeler or whatever it is. There's always something that somebody promised to them, and they want me to take it to court and argue that case, right? Well, it becomes really difficult because we have to prove that it's a will in order to prove that they're entitled to it and that it's going to supersede the default rules that give everything to the kids in equal shares without discrimination, right? And again, we don't have those records on the books to say, hey, if somebody if they said something, that we can go ahead and tell the court that they said that and then have that enforced as a valid will. Even if we could, and in some states, I understand they do allow you to make those arguments and the court gets to judge what the intentions were. I mean, it becomes very difficult to prove and very difficult to disprove. So at the end of the day, it's guesswork, which is why the law requires your will to be in writing in the first place. Now, I have seen a lot of cases where people will come through with something that purports to be a will, and then it turns out that it is, even though it's very easily challengeable. And one of those wills is the ones I mentioned earlier, which are the holographic wills. More than once, we've had clients come in with a piece of paper signed by the person who has passed away that says, hey, I want, Johnny to get the baseball bat or whatever it is, right? I can't get into specifics with specific clients, but it's always something of that nature. And then usually, it's a valid will and we can take it to probate and we can say, hey, this is their will. But if it's going to count as a holographic will, it has to be in their handwriting, which is easily challengeable because now, an opponent that wants the baseball bat can come through and say, well, this isn't their handwriting. This is somebody else's handwriting. Usually this is the beneficiary's handwriting. They wrote it for themselves or their attorney wrote it for them and they signed it. And then we have to get handwriting experts and we have to get all kinds of different people into the courtroom to prove whether this will was written by the testator. That's the reason why we have witnesses in the first place. Because if we have living people, or at least people who have said, we know this is their will because we saw them sign it, that's evidence in the state of Utah that this is their will, whether or not it was in their handwriting. So it generally leads to less litigation. There's another step you can add on. If you want to prove that the witnesses saw the testator sign the document, then you can put what we call an attestation clause on the back of it, where you say, yes, we have a notary sign a document that says, these witness signed this document in my presence, and they swore under oath that this is a valid document, that they witnessed this person signing the document, and then it's conclusively presumed that this is a valid will. So anyway, you get into all kinds of things with wills.
It sounds really complex. So then let me ask you the other way around. If somebody is thinking about formulating a will and wants to avoid all of the potential fights that are going on and goes to, what are some of the things you ask for people to be prepared with to come sit down with you?
I always ask people about their family circumstances, right? Not just, who are your kids? How are they doing? But how are they getting along? What are the interpersonal relationships among your children? I think that's important because it gives us a read on how critical this might be. And any estate can fall into chaos and generate conflict. But sometimes you know that in advance. You can look at the family situation and say, yeah, these people are going to fight about this. And what do you do about that? Well, we can put clauses in the will that say, you know what, if so-and-so or if any of the kids brings a challenge or brings a fight to court, then they're disinherited. It's called the contest clause, where we say, hey, everyone gets an equal share. That's fair enough. But if somebody makes it difficult, then they're written out and they don't get their share. So there's a disincentive. And if they want to fight, they can fight. We can't stop kids from disagreeing, but we can prevent them from bringing a case in court to challenge the will.
So really quick, we're on the first break here in 1 minute, but really quick, do you ask them to bring lists of items to be specifically mentioned?
I talk to them about it in the meeting. I don't bring it with them. And the reason for that is if they don't care, we don't want to list everything out, right? Everybody has a list of tons of things. But if there's a specific item that needs to go to a specific person, I always ask that question and we can address those on a case-by-case basis.
Okay, perfect. Thank you, Justin. This is the Senior Moments Show. Again, we are sponsored by the Empowering Seniors Group, and Justin is a member of the Empowering Seniors Group. We are at our first break. When we come back, we'll make sure, if you want to grab a pen and paper, that we'll mention the phone number in case you would like to set up a will with Justin. Again, this is the Senior Moments Show. We're going to take a short break. Stay tuned. We'll be right back.
Did you know 1 in 3 people will visit a nursing home? Did you know that once there, they will stay there for an average of 3 years? Did you also know there are insurance options that can help cover this experience? Hi, I'm Tracy Ferris with Blue Water Health Insurance. It's not cheap to stay in a full-fledged nursing home. Long-term care insurance can help you or a loved one get the care they need and deserve. If you wait until you need it, you may be too late. Give me a call at 435-890-8155.
Picture this. Your family's locked in court, fighting over your home and your assets because there was no plan. Don't let probate decide your future. I'm attorney Justin Wall with Wall Estate Solutions. Stay in control with wills, trusts, and smart planning that keeps your family out of court and your wishes protected. Get peace of mind today. Visit wallestate.law or call 435-294-0346. That's 435-294-0346. Your legacy, your plan.
This is Mark Thurston with White Pine Funeral Services. The best time to plan is when you have time to plan. Having a pre-arranged funeral gives peace of mind for everyone involved. White Pine will customize your final wishes to fit your needs, from a traditional burial to cremation to a custom headstone. White Pine also accepts pre-arranged plans from other mortuaries, and we will absorb any transfer or revocation fees. No penalty to you. Visit whitepinefunerals.com or come and see us for more information.
White Pine Funeral Services, here when you need us most.
Getting around your home should be easy and safe. At RT Med Mobile, they provide wheelchairs, stair lifts, ramps, and electric lift chairs to help seniors maintain independence and comfort. Their friendly team offers free in-home consultations to find the perfect solution for you or your loved one. Locally owned and here to help, Call 435-260-6171 today. RT Med Mobile, because your mobility matters.
At Maple Springs Senior Living in North Logan, we understand that entrusting the care of your loved one to someone else is a decision not taken lightly. That's why we go above and beyond to create a nurturing environment where your family becomes our family.
When I found Maple Springs, it was like a weight lifted off my shoulders. The staff here really cares, and Mom is thriving.
The activities and social events have brought so much joy to Dad's life. I can see a positive change every time I visit.
We know that your loved one's well-being is your top priority, and it's ours too. Learn more at maplesprings.living.com.
Need a helping hand? The Bear River Association of Governments, also known as BRAG, is here for you.
They assist seniors with in-home services, provide utility bill relief through the HEAT program, and offer rental assistance to keep you housed.
Need help with tax prep? Their experts ensure you get the refund you deserve. And for veterans, they're here to connect you with the benefits you've earned.
BRAG is your local resource for a stronger today and a more secure future. Call today or visit brag.utah.gov.
Welcome back. This is the Senior Moment Show, visiting today with Justin Wall with Wall Estate Solutions. We've been talking about wills, and I did promise if any listeners would like to contact Justin, what's your contact information?
Yeah, great question. So best number to reach me is 435-294-0346. That's 435-294-0346 for calls and consultations.
Wonderful. And then in the break, actually, our producer had a little question. I thought it was really relevant.
Yeah, thanks, Eric.
What if I wrote my will 20 years ago? Is it still valid?
Yeah. So the answer is yes. There's no statute of limitations on a will. If it was, we've handled wills that were older than that. I've seen them come through my office 30 and 40 years ago, or 30 and 40 years old, excuse me. And they're still valid. There's nothing in the books that says, hey, they're not valid anymore. What we're looking at is not whether they are valid if they were valid when they were written. What we're looking at is what's changed, right? So for a lot of people, they'll write a will in their 20s or 30s when they have small kids at home. And then they'll come back 20 years later, 30 years later, which I think is too long, but they'll do it anyway. And we'll look at the will and it doesn't apply at all. We don't have minor beneficiaries anymore. We do know what they're going to look like as adults, so we're not using generic language for what if and what if that. We're looking at, okay, this person's going to have a substance abuse issue. This person's great with money. This person has passed away and has children of their own and their spouse has gone and remarried. I mean, these are the situations you don't know when your kids are younger. So changed circumstances is what we need when we're looking at whether we update a will, and that can happen at any point. For most people, on the personal side, you'll call me if something changes with your marriage, with your children, with your family dynamics. And we recommend reaching out every 2 to 3 to 5 years to make sure there hasn't been a change in something related to the law. There are laws that change all the time related to wills and how different assets are taxed in different ways, and that needs to be reviewed, if not updated, once every 3 to 5 years.
Yeah, thank you, Justin. And I think we've talked about that maybe at a different show before, but what are some downsides of the will?
Yeah, so the biggest one, and I don't think a lot of people understand this, is a will doesn't avoid probate. If all you have is a will and your kids bring that into me after you pass away, a lot of times they come in expecting this to be a quick, how do we get this all taken care of? And my first thing to tell them is we have to go to probate. And the reason for that is we don't have anyone who has legal authority to sign a document, to transfer the asset. So if you've got a house, for example, the owner has to sign the deed. And if we don't have a living owner, then we have to go to court and ask for permission for somebody to sign that deed on their behalf. That's the personal representative in the state of Utah. It's executor in other places. But the bottom line would be, how do we get that person appointed? We have to go to probate. Even if the will has been written and even if the will clearly states who's in charge, we still have to get that person appointed. Yes, they have priority of appointment, so the court will probably pick that person absent some objection. But that we still have to go to probate and get that process started in order to do anything with any of the wills.
So you just mentioned, there's a representative that needs to be appointed in probate. What are some other ramifications that happen, and what's the timeline?
Yeah, so the timeline in probate, we're looking at, minimum 4 months probably. More commonly, a lot of these are going 6 months to a year, depending on, banks and IRS, taxes, those kinds of things. Because we have to open the case in probate, and when we do, we have to follow the state's rules. And one of the state's rules is, hey, if you want to make sure that you've settled with all of the creditors, you have to give the creditors a chance to settle their debts. So if you have a case where somebody has an outstanding credit card bill, or a medical bill is a very common one, Well, we can pay those off and assume that we're done, and then there might be one we don't know about. And if we make distributions, then those creditors come after those beneficiaries to get that benefit. Or we publish notice to these creditors, the third parties, and then we say, you know what, respond to this and come to this probate to get your claims. And if we go past the 90-day limit in Utah, then you don't get a claim. And then we know after the 3 months that we do have all the creditors and that we do have, everybody that's going to make a claim against the estate has made a claim against the estate. And if somebody forgets or doesn't respond to our notice, then we don't have to worry about them. We can make the distributions, and they're likely going to be barred from bringing a claim. So that's one of the things that takes some time. Another one is, especially with retirement assets and other things that generate income, we have to report income to the IRS, and sometimes that means we're waiting until the next income tax cycle and other things that come up. But generally speaking, the quickest we could get a probate through would be 4 months.
Wow. And I've always wondered a little bit, you mentioned the creditors. What if the kids go through the house and they don't, maybe there was a P.O. box and they don't see some of the mail that was intended?
Yeah.
What happens here?
So it's the same thing with creditors. The rules are the creditors have to make their claim after we publish notice. And
so where do you publish notice? How does that work?
So great. So publishing notice, we have two ways to do it. If they're unknown creditors, we publish it in the newspaper because we don't know who you are. But if you have a claim and you care, you're going to be watching this newspaper for if this person passes away, right? That's what gives us our 90-day notice. If we know about a specific creditor, which is where we get the P.O. box, we either check the P.O. box or we don't. If we know that they're trying to make a bill, then we send them notice and say, hey, make your claim in probate because a letter in the mail is inadequate for this kind of a claim. Okay, and then they send us the notice, and if we get the notice, we can settle it at that point. But that triggers a 60-day statute of limitations. So if we know about creditors and we send them direct notice, then it's a shorter period for them to settle that out. And if they choose not to respond, it doesn't matter if they're sending us letters every week. If they don't respond to the claim as a response to the probate claim, then it's not going to count against the statute of limitations.
Okay. And just another question that came to my mind with all of the personal items, maybe art pieces, maybe things that have value.
Yeah.
As you said, grandpa's old hunting gun.
Yeah.
I mean, if it's split 3 ways and nobody's made anything specific, how does that work?
Yeah, so it depends on how the will is written, but generally the will is going to keep it vague, right? And they're going to say, well, we've got 3 kids. We're going to divide it 3 ways between the 3 kids. That's 3 ways as the total value of all of the assets. So if we have a piece of art that's not named specifically, we have to get that piece of art appraised and figure out what it's worth. And if it's worth $5, great, give it to the kid that wants it and get the $5. If nobody wants it, we can sell it and we can take the money and we can split it 3 ways. Shotguns, rifles, firearms, those kinds of things, the same thing. What is it worth and who wants it? If it's not specifically listed in the will, then it can go wherever the personal representative decides it should go, after hopefully consulting with the beneficiaries to try to reduce conflict. But it's generally very open-ended in that regard.
Perfect. Sounds really complex. So how long, really quick, we're almost at our second break, really quick, how long does it typically take for you to write a will or help someone write a will?
Yeah, my process is about 2 weeks. They'll come in, we'll sit down. The first consultation we go through, what do you want to do and how do we want to set it up? And then the second meeting is what I call the document review meeting, right? We want to sit down and show you the will before we're asking you to sign it so that we can make sure you're comfortable with it and that you don't feel pressured because we're signing today to stick with something that you don't like. And then my third meeting is that third week, 2 weeks in, and that's about how long it takes.
Perfect. And what is there like a fixed cost that's associated with it, or do you charge per hour?
Yeah. So for will plans for individuals and married couples, it's generally around $1,500 to $1,800, and there are some factors that will determine that, but that's the rough range for a will.
Perfect. Thank you, Justin. This is the Senior Moment Show. Again, we are visiting with Justin Wall, attorney at law at Wall Estate Solutions here in Logan. We're going to take another break. Stay tuned. We'll be right back.
Are you tired of feeling unwell and not knowing why? At Next Level Health and Wellness, we hear you. We specialize in uncovering the root causes of your discomfort, whether it's gut health, hormone imbalances, or emotional and mental blocks. With personalized plans, advanced lab testing, and evidence-based holistic nutrition practices, we guide you toward lasting health and wholeness. Awaken your healing potential with a team that listens, understands, and supports you wherever you are. Visit nextlevelhw.com to start your journey to feeling better today.
Picture this. Your family's locked in court, fighting over your home and your assets because there was no plan. Don't let probate decide your future. I'm attorney Justin Wall with Wall Estate Solutions. Stay in control with wills, trusts, and smart planning that keeps your family out of court and your wishes protected. Get peace of mind today. Visit wallestate.law or call 435-294-0346. That's 435-294-0346. Your legacy, your plan.
Want an inexperienced surgeon?
Okay, nurse, I'm ready for the scalpel.
How about an inexperienced airline pilot?
Ladies and gentlemen, this is your captain, and I'm terrified.
Experience matters, and we have it.
Hi, this is Sid Roeder with Achievement Realty. I am a senior real estate specialist.
I'd love to meet with you face-to-face and give you a free consultation and market analysis. Call me today at 512-6406. Then list it, sell it, and move on.
Did you know that one of the greatest threats to our quality of life is a fall? 1/3 of Americans 65 and older, and 1/2 of those over 80 will fall this year. Many will never be the same again, and some will never return to their homes. This is Bruce at Comfort Care. One of the ways we can help people stay in their home is through our free in-home fall protection survey. Let us help you identify these fall risks. Call us at 754-7676. Comfort Care, 754-7676.
This is Oliver with Cache Valley Pharmacy. We're working with Cache Valley's own Focus Pharmacology and CacheMedical.org to help you lose weight the right way with supplements that support your weight loss journey and easy telehealth appointments from the comfort of your own home. When you think weight loss, think Cache Valley Pharmacy, your partner for a healthier, more confident you. Visit us at CacheValleyPharmacy.com or go to CacheMedical.org to start your weight loss journey today.
Welcome back. This is the Senior Moment Show. I'm your host, Sid Roeder, visiting today with Justin Wall with Wall Estate Solutions here in Logan. And we've been talking about everything will and the downsides and how long it takes and what it costs. And I can't hold back. I'm sure there are some stories that are worth telling without naming names.
Yes. I mean, there are a lot of stories out there, of course, this has come up millions of times throughout the country, and there's case law and everything. One of my favorites when it comes to wills, I had a friend who set up an estate plan for this, or was doing a probate for this person that had a mixed family situation, and mixed families tend to be they tend to be more contentious. Not always, but in a lot of cases, there's a lot of tension between a surviving step-parent and the children of the deceased. So this case, my friend was working with, I don't know if it was the surviving child or the step-parent, but anyway, they came to him and they asked him about this holographic will. They said, well, we think he wrote it down somewhere that we were supposed to get the house, which in that case was one of the major parts of the estate. It was one of the major issues. So this friend of mine was telling these clients about this holographic will statute that said, hey, if you can find something that's in their handwriting, it doesn't have to be a will. As long as they wrote it down somewhere and signed it in their name, then that's going to be legally binding as a holographic will if we can get it through the probate courts. And all of us in this field have done that at one time or another with a holographic will, so we know it works. But anyway, he said, the very next day, the client came and said, oh, look what we found. We were digging through their boxes of old stuff, and we found this will. And it was exactly everything that needed to be in a holographic will and nothing else, which is what he had just explained to him yesterday, right? And he said it was just too clean. He's like, this doesn't look like the kind of thing that sat on the bottom of a box for 15 years and then was suddenly found after it was dug out of this mess. And he ended up not taking the case. But I mean, that's the kind of thing where you just never know what people are going to do, what people are going to try. And probate court, it gets messy. A lot of people will play dirty, and you have to keep an eye out for that. And in other cases, I mean, I don't even know how many times I've had people come through with handwritten wills. I've had people come through with wills that had certain things written on them that was very specific. Hey, I want this person to get the car. Okay, great. That's a will. Sign it. Great. That's the only piece of it. So we have to default to the statutes for everything else. I've had some come through where they wrote out most of what they wanted everybody to get. And then they didn't have a residuary clause, which says, hey, everything else in equal shares to the kids, which we have to default to the statutes on that too. Sometimes they come through and the will is valid as to the assets that are being distributed, but they don't name a personal representative. And now we have to go and have sometimes a court fight about who gets to be in charge of making all of this happen, even though everybody agrees that this paper is their will as informal as it seems. So, I mean, things like that come up. It's kind of fun.
I wonder too, do you assist or mediate if the kids can't? Because I mean, I know personally of a case where the same painting that was done by grandfather was promised to everyone. If they can't agree, what do you do? I mean, obviously nobody wants this to be sold.
Yeah, those are sticky cases, and I call those the baby blanket cases. A lot of these cases are things with sentimental value, but no real value. And so bringing an attorney on board is already a loss in itself, at least financially, monetarily. But there's so much sentimental value attached to this item that nobody cares, and they're willing to spend tens or hundreds of thousands of dollars fighting in court over these kinds of things. Your question whether I mediate, I don't usually take those kinds of cases. Of course, I'll consult with anybody, and if we can sit down and figure something out quickly and easily, we will. But there are people that do professional mediation for that kind of thing, and usually I'll send them out to those third parties.
Okay. Is there anything that sticks out in your mind that was the most unique item ever fought over?
There's a famous case in Arizona, and it's known throughout the entire country, but I happened to be an Arizona lawyer when I started practicing law. There was a painting sold in an estate sale. And the painting was this thing they found in the attic, and they thought it was worth $20, $25, and they ended up selling it at the estate sale for $20 or $25, something on that order. It turned out to be one of the original lost Raphael paintings that had been sitting in Mom's attic and ended up sold. I don't remember it off the top of my head, but the painting sold by the buyer in an auction for $6 or $8 million. And then there was a whole bunch of litigation against the personal representative who sold this without doing an appraisal on the painting, because an appraiser would have been able to spot that this is a very valuable item, right? And the estate personal representative made an argument that they didn't know what its value was, and that they wanted to unwind the original transaction so they could get the Raphael back into the estate. And the court ended up ruling against them and saying, no, you made the sale, and it was on you to do your due diligence to make sure you knew what you were selling, and the buyer is entitled to rely on the fact that you maybe know or don't know what you're doing, right? And so the sale stood, and the estate personal representative ended up getting sued for the value of the painting. I'm sure they went into bankruptcy after that, but that's the kind of thing that you want to watch for if you're going to act as a personal representative.
Wow, crazy. Don't underestimate what people have in their attic, right?
Yes. I always tell people if there's any chance it could be worth anything, we can always get an appraiser to value anything. And then at the very least, you've got their liability insurance to fall back on if they're wrong about something.
Right. That's perfect. We're coming up on the end of our show, so I don't want to lose the opportunity to have your contact information one more time.
Sure. So again, Wall Estate Solutions, if you call me, you'll get to Justin Wall, 435-294-0346. That's 435-294-0346. Office location 701 South Main Street in Logan.
Wonderful. Thanks for coming in, Justin. It's always great to learn.
Always a pleasure to be here. Thanks for having me.
That's great. This is the Senior Moments Show. Let me mention our sponsor again, which is the Empowering Seniors Group. If you'd like to learn more about the Empowering Seniors, you can do so online at empoweringseniors.info, or you can email us at empoweringseniorscv@gmail.com, and the CV stands for Cache Valley. Sadly, we're at the end of our show. I hope this was educating, and you tune in next week.